So let's get on the record. In the State versus Stevenson Alexander, I have 3 cases: 22 SC 182 429, 22 SC 183 196, and 22 SC 184 175. They're all shoplifting cases, and in each of them, there is more than 5 years. There are more than 5 years remaining on probation. I signed warrants in each of those 3 cases in January of this year. The allegation in the warrant is that Mr. Alexander in November of last year was arrested by the Atlanta police for a new shoplifting charge. And there's an additional violation alleged that Mr. Alexander did not enroll in and successfully complete sober living. We were together a few weeks ago, maybe a month ago, at which time Mr. Alexander told me that he wanted an evidentiary hearing. In other words, for the state to prove up the arrest for shoplifting in November of last year. So we reset this so that Ms. Dilligard could get the right witness or witnesses here. But a few days ago, Ms. Rios sent an email out saying, we're withdrawing the demand for an evidentiary hearing and we'll focus on sentencing hearings, the wrong term to use, but sorting out what are the consequences for these 2 violations of probation. Is that still the situation, Ms. Rios?
Yes, sir. So when I had court, when I talked to him, I think it was a little confusing. He said he didn't want an evidentiary hearing and he was just wanting to find a program. Mm-hmm. And so that's what we've been working on the last few weeks, to get him finding out the options he had with programs.
Got it. Okay. Don't worry, Mr. Alexander, you're gonna time to talk. So what you've been working on, you and Ms. Ross and others may have been working to find program or programs for Mr. Alexander.
Yes, sir.
Okay. Are you prepared to go forward with whatever those recommendations are?
Yes.
All right, Ms. Dilligard, are you ready to go?
Yes, Judge.
Mr. Alexander, tell me, you are giving me that look I'm familiar with, which is, I don't like what's going on here. I know you're not confused in the sense that, but tell me what you're confused about. We've been around and around. You are a sophisticated individual. I've worked with you in drug court. I've worked with you outside of drug court. What's the confusion?
I'm getting something else being told about about this evidentiary hearing. I never, like, to my understanding, when I last spoke with her, she's telling me about this evidentiary hearing is about something that I'm on probation for, shoplifting for. It's something about trying to get some cases for my charge that I'm on probation for. That's the understanding of what I took. I did not know the evidentiary hearing is about the new shoplifting charge that I caught from last year about trying to say that up.
So I've probably said something that was confusing, and I'll own that. Let me tell you what this is not about. This is not about you pleading guilty to the new charges or anything like that. But if we go forward with an evidentiary hearing, what probation has said to me is, hey, Mr. Alexander's not doing so well on probation. And there are 2 reasons why he's not doing well. 1, he shoplifted again, and he's on probation for shoplifting. So we think there should be a consequence for that. Number 2, he didn't complete sober living. Put that one to the side. Let's focus on the shoplifting. Unless you stipulate or admit, hey, I got arrested for shoplifting again, the only way that I can decide there should be consequences for what happened in November of last year is for the state to call a witness. Maybe it's a loss prevention officer. Maybe it's an Atlanta police officer to say, I'm doing my work. There's this guy. He runs out of the store. He's got a bag full of stuff. He didn't pay for it. And it's on video and it's you. I'm making it up. But let's say what the evidence is. I would be finding then not, you're going to jail for the new charges. I don't know where those new charges are. They haven't been indicted yet, probably. I'd be deciding, here is the consequence for your probation, because while you were on probation, I've concluded that you did another shoplifting. That's what the evidentiary hearing would be about, is for the state to persuade me, if they can, that in fact, while you were on probation in November of last year, you did another shoplifting. And if I agree with the state, you're not guilty of the new case. We're just dealing with, what's the consequence for what you're doing on probation? Does that clear it up? Because if it doesn't, keep asking questions.
No. It clears it up.
Okay.
I have no problem with that. All right, I have no problem with that. My argument about that new charge, that's between me and that new charge, and it ain't got nothing to do with it, right? I understand that part. Okay, now, like you said, you're innocent for purpose guilt. That's something I gotta deal with probation. I go to court on the 29th for that. But I got this charge because they did something they did a real misconduct on my charge, which is supposed to be dismissed, and I want to fight it all the way to the trial. But now, since clearly you're telling me that it's a violation by me getting arrested for that charge, I'm gonna have to live with that. But that's another issue. The other issue is about this, which my lord is trying to explain about the civil living part.
And I'll hear her about that. And you told me a little bit about it last time.
Yeah, because I tried to enroll in there, but now she got put that I tried to enroll inside there, so I'm trying to get it from here.
Okay, so you feel like things are cleared up a little bit. All right. Ms. Rios, why don't you get us started then?
Yes, Your Honor. Mr. Alvin has had a, long history with the G, and I'm sure you're aware of with the drug court. We did try to do drug court again. They denied him when we did an application to drug court. But sober living said that they would allow him to come back. And to me, I don't know exactly what happened when he tried to go, but the fact that they're saying that he could come back says to me that maybe it wasn't all on him. I'm not sure. Don't know exactly what happened. And so, but they're saying that they would take him back if it's court ordered. They said he's done the intake process. Ms. Ross was on the phone when they did the intake process. And that's where he would like to go and try to see if that helps with all his history, these new cases. I know he's saying that he's trying to fight the new shoplifting, but they all say from his abuse, his drug abuse issue. He's not a violent felony. I don't believe he is a danger to society as a whole. And so I'm asking that you revoke the time that he's been in and allow him to go to the sober living program.
Okay. Do you have a PI number or anything for that? I have a booking number, but
I have an SC number.
You have an S, it's been indicted?
Yeah. It's
after me saying it hasn't been indicted?
It's in non-complex right now.
For now?
Yeah.
Okay.
24 SC 006463.
Okay, you do have a hearing on the 29th. You're right. I don't think it's one where people are going to be throwing the case out, but it was dismissed originally. It meaning that charge in December, it was dismissed. This would explain why you have a new booking number, because the officer didn't show up. Not because it's a good case or a bad case, and I'm not telling you it's a good case or a bad case. But if an officer doesn't show up for a preliminary hearing twice, then that second no-show, the judge says, we're throwing the charges out. And so if you were still in custody, you would have been released if this was the only thing holding you. The DA's office is still free to bring those charges because the judge didn't say they're bad charges or there's no evidence. They say we don't have an officer here to establish probable cause. That's what happened in your situation. It sometimes gives a defendant a false sense of hope that, see, my case is no good. The judge threw it out. The judge didn't say anything at all about good case or bad case. She basically said bad officer because the officer didn't show up. So I'm going to take a quick look at.
I have a valid argument.
I bet you do, but this isn't the place where we need to go into that. Okay. Ms. Dilligard, what is your recommendation for Mr. Alexander?
So my notes indicate that this would be his second revocation. He had a revocation back in October of 2023 for a new offense and also some technical violations. He was revoked 7 months then. And that was just a few months after pleading guilty on this case.
You said in October of 23?
Yes.
Okay, I see it.
And I also see that he has at least 5 theft by shoplifting convictions. After conversing with probation, I believe probation's recommendation was to revoke 3 years for a minimum of 2 years to be revoked from his sentence.
Okay,
I have a question, sir.
I'll get to you in a sec.
I believe his original sentence was 8 to serve 1 on the 4175. Is that what it's?
Okay. So the order that I entered that revoked the 7 months said, here are the findings. He didn't report, he didn't complete sober living, and he had a new shoplifting. So all those things you said. Interestingly, the special conditions, I modified the special conditions. 1, it set a behavioral incentive date. That didn't go well. But 2, it said sober living America no longer needs to be completed. So I'm wondering if half of this particular warrant we ought to set to the side. And I'm going to ask Ms. Simpson with DCS to let me know if, since this order was entered in October of 23, was there something that happened after October of 23 where sober living was reinstated as a condition, or maybe just someone didn't connect the dots?
I believe this officer hadn't realized that you had removed that part of the special condition.
Okay. All right. Got it. Anything else? Well, let me start with Mr. Alexander since he's raising his hand. Yes, sir.
Yes, all right, back to what you were saying, what you violated before, for the first violation, because to my understanding, I feel like I got revocated because I didn't report. Now, the new charge, what new charge did I didn't catch no new charge on that. And I thought, I thought I made it clear from the first time you revocated me and sent me down there for 7 months, straight day for day. I'm thinking that I'm gonna be in jail, doing half that time and get released from jail. You gave me 7 months, day for day.
I did.
Yes.
Yeah, I agree. That's exactly what it says.
Because I'm like, okay, for not reporting, I didn't catch no dirty urine. I didn't catch no open charge.
Right. So we're going to disagree on that one. What I put in my order and what I had evidence in front of me was 1, you didn't report.
Okay.
2, you didn't complete sober living. 3, the big one, you had another shoplifting, May of 23. Okay.
That was the thing.
Well,
That was the thing.
we don't need to litigate that now. You did your 7 months. That's water under the bridge.
For nothing. I mean, for false accusation. I'm a victim of false accusation. That's what I'm saying.
Okay.
Okay, because you sent me down there and then I'm trying to get my head straight. Like, why am I going back to prison when I say you didn't do nothing wrong? And then I'm only 2 months out of jail. 2 months out of jail. I only missed 1 time. And you revocated me. And I'm trying to get that clear. I mean, out the way. I mean, like, that understanding I did is like, I was confused. Why am I going back to prison for not going to, for not reporting? Okay, that's the charge. Listen, I did not catch the charge. I had no open charge. And then I clearly explained that to you for the first time when I first got revocated. I thought I cleared that. But you told me out your mouth saying that, well, the reason why I'm revocating you because you could have showed up to your probation officer. You could have went to the probation office because my job was to stay at home and wait for the probation to come see me. That's that.
We gotta talk about the correct thing.
No, this has to be in there because you bring it up. I have to bring it up because now I'm clearly saying that I've been falsely accused false application. Yeah, it was false accusation. I mean, it ain't no due process right there though. It ain't.
Okay, you keep going. I'm listening. I'm looking up your arrest and I'm happy to talk.
Because I got done wrong. I ain't had a dirty urine. I had an open charge. I know I had no open charge. No fact. My family can vouch for that, and they're not here right now. That's why that's the reason why I kind of got upset out there because I'm not prepared.
Got it. So here's what we got. You were arrested in May of 23. There's your booking picture, tattoo on chest. Gladys Alexander's your emergency contact. And you were arrested. You have a failure to appear at a East Point and
Yeah, East Point, yeah.
yeah.
That charge was 2 years old. That's not no new charge. That's not no new charge. That's what I was trying to explain.
You're right. It's what you were arrested for was this failure to appear. You were arrested on May 20th on that warrant. And let's see what else is in the system about that.
That was a 2-year-old charge. Way prior before I got sent to this probation. It was way before that. That's like a double jeopardy type thing to me. That's what it sounds like right there.
Then in 2024, the district attorney's office declined to prosecute you for the charges that were connected with that arrest. So you that may be something you want to explore later on as to what the arrest was for and how it shows up as shoplifting. Because if you look at what you were booked in for, it was this failure to appear. It says theft by shoplifting here. Maybe it was a failure to appear for a real old shoplifting case. And yet it showed up in the system as here we are in May of 23 and you're getting arrested for a new shoplifting case, but it was actually an old shoplifting case. Got it. Okay. Well, you can be sentenced to less than 2 years for technical violations like absconding and not completing sober living. So that sentence you did get, that revocation, back the 7 months was for not completing sober living, not reporting to probation, and supposedly the new shoplifting, which you're helping me understand, was actually a real old shoplifting, and what you got arrested for was a failure to appear. The 7-month revocation is still a legal sentence for just the two of not appearing and meaning not reporting to probation and not completing sober living. But you know what, Mr. Alexander, I'm going to cut you.
The sober living, I told you that when I went to sober living, I told you I had to pay a little I owe rent over there. I couldn't be admitted inside sober living. I went home that same day. I went to the probation officer that next day and explained what happened. The understanding was for me to stay at my mother's house.
Okay.
That's it.
Well, that revocation has already happened. We're here on a new one, and the basis for the new one is a new shoplifting, not a failure to appear. It's a new shoplifting. You got arrested with a bag full of meat, hadn't paid for it. You're going to fight that in non-complex, although it will likely move out of non-complex.
So I'm just gonna be done wrong again. So it's like I'm just gonna get revocated again.
What part's
I'm gonna be the first time I got revocated for. I got real.
okay?
Plain and simple. Plain and simple. It wasn't fair. It wasn't no fair hearing.
What part's not fair this time?
Huh?
What part's not fair this time?
I'm not talking about this time. I'm talking about the first time.
Okay, I'm talking about this time. Now we're good.
Right now, it is what it is right now, because see, right now, I'm supposed to be going back to a sober living program and get my life straight. And then clearly, man, you see I'm an addict. You see I'm an addict. You need help.
You do need help.
I need that help.
And we have tried hard. Drug court was your big opportunity, but that one didn't work out so well. Mr. Alexander, in light of your recent arrest for shoplifting.
One moment, sorry, I just wanted to add one more thing if I could.
Really? Okay.
Sorry about that. There is an additional arrest from February 27th of this year that is on the petition that Ms. Simpson just provided me in counsel that he signed back in March.
Okay. And what was that arrest for?
Possession of MDMA.
Okay. And that's the booking number we're dealing with now. There is a 25 booking number. So it's not a booking number in connection with the shoplifting. I thought it was a booking number in connection with the probation warrant, but it's also connected to new charges.
Or meth.
Is it on this one?
I
Is it
didn't
on
make
this,
no
this one just says stop.
Yeah, let's do that.
Well, I don't need to get there. There may be a new case for Mr. Alexander to work through at a later date in connection with those new charges. But I want the record to be very clear that based on, it's just one violation remaining in the warrant that I signed. One of them was not completing sober living. That wasn't a condition anymore. But Mr. Alexander was arrested yet again for shoplifting in November of last year. It's an indicted case. It's moving its way through non-complex. It will likely get bumped to a superior court judge. In the meantime, I'm going to revoke 2.5 years, 2 years, 6 months of Mr. Alexander's probation in each of the 3 22 SC cases. I will reinstate the balance, and I will add as a special condition, so it's back at Mr. Alexander's request, a directive that Mr. Alexander enter into and complete the sober living program, because he has told me about 5 times today on the record that he needs sober living and he wants to do sober living. So he'll have another chance to do that. Thank you.
So, to my understanding, you're broken 2.5 right now?
That is a correct understanding.
I guess, Judge, we're just, trying to, will this next, the meth case come back? You have to have another revocation on that one.
So,
I didn't find out about this till today.
right. And so you weren't expected to be ready for it. We weren't going to postpone what we were doing today. And I made clear on the record that today's revocation of 2 years and 6 months is predicated exclusively on the shoplifting arrest from November. Not a sober living issue, because that actually was not a condition anymore, and not because of the MDMA.